Hello, my name is Michael Tesoro, and I prepared this video case note entitled All at Sea, Carnival, PLC, and Karpik, the Ruby Princess case. And the reason I've called it All at Sea is because it's a pretty unsatisfactory judgment by the full federal court. The justices seem to not be able to agree on any of the various issues that are raised and come up with conflicting views on a number of issues. And I think it actually creates more questions than it answers. So I think it's fair to say that the decision is pretty well all at sea. Now, a bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice as sale legal consulting for the last 15 years, and I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as a director of enforcement. Now, on the presentation, I'll start with the background facts, then look at the primary decision of Justice Stewart, then go through each of the judgments of the full federal court. Derrington is the lead judgment. Allsop agreed with him on a number of key issues, and Rares is a dissent. So I'll go through each of those three judgments and then finish with some commentary. Now, the background of the case, well known that the Ruby Princess came to Sydney during the height of COVID, and a number of the passengers had contracted COVID. And so this is a class action seeking damages for people on the vessel who suffered injury. Some actually died. So it's seeking compensation for various passengers. And they're different groups of passengers, but this case relates to 696 US passengers who are included in the class action of 2,500 passengers. And the question is whether the class action as it relates to the 696 US passengers can continue in the Australian courts. Now, the four questions that have to be addressed by the courts. The first is whether the US terms and conditions form part of the relevant US passengers contract. Secondly, whether the exclusive jurisdiction clause was enforceable in the US terms and conditions. Thirdly, whether the class action waiver clause was enforceable. And that all turns on whether it's an unfair contract term within the meaning of Section 23 of the Australian Consumer Law. And finally, whether the class action as it relates to these US passengers should be stayed, which is a discretionary consideration. Now, the exclusive jurisdiction clause is stated there. It's a clause which relates to claims for injury, illness, or death, and it's a fairly standard clause. It says that any such claims must be litigated before a US district or federal court. Then there's a class action waiver clause which says that the exclusive resolution of any disputes have to be pursued through individual legal action, that signatories to this contract are not permitted to join up through to any class or representative action. They can't pursue any claims through that mechanism. Now, Stu in the first instant refused the stay application, so he refused to stay the US component of the Australian class action, and his primary ground was that the US terms and conditions were not incorporated into the US passengers contract. And that was because he formed the view that the relevant travel agent who facilitated various aspects of the trip was not the lead plaintiff's agent. So the lead plaintiff was a person called Mr. Ho, and Justice Stewart concluded that the travel agent had not been acting as Mr. Ho's agent. Alternatively, in the event that Stewart was wrong on that point, he concluded that both the exclusive jurisdiction clause and the class action waiver clause were unenforceable and should not be given effect because they were unfair contract terms. Now, Derrington, as I said, he wrote the lead judgment, and the first issue was to determine whether the travel agent had been acting as Mr. Ho's agent. And he concluded that as soon as a travel agent entered relevant details on the online computerized system, Polar, and entered the necessary data on behalf of Mr. Ho and paid the deposit, then there was a binding agreement between Mr. Ho and Princess, the subsidiary of Carnival, and that the only way that the travel agent could have done those steps was if she was the agent of Mr. Ho. So he concluded that the travel agent was acting as Mr. Ho's agent, and also have agreed with that particular finding. Then, once the agency relationship had been established between the travel agent and Mr. Ho, then it stood to reason that the US terms and conditions were incorporated into Mr. Ho's passage contract. And then Derrington had to move on to consider whether the terms were enforceable or unfair. And he started looking at the various ticket cases, and there's quite a long discussion of all the cases going over many years. And he discusses the difference of opinion between the subjective and objective theory of contract. Actually quotes Lord Denning, who raises the obvious point that it's quite artificial to expect a customer who's just about to board a plane or a boat or a train to read all the terms and conditions of their passage prior to undertaking their trip, and it's quite a fictional expectation. But Derrington takes a very, I guess, formal approach and said, well, it's objective theory of contract. It doesn't matter whether the person affected by the contract knew on a subjective level what the terms and conditions were. It's rather whether they've been provided with the relevant contract, whether they've been given an opportunity to review them, and whether clauses have been brought to their attention. So in the particular case, he concluded that Mr. Ho had been given appropriate notice. So the first obligation, obviously, is to provide appropriate notice to the consumer of the relevant terms, and a second obligation to actually bring to the consumer's attention any unusual or onerous terms. So things that the consumer wouldn't ordinarily expect to be in a contract have to be highlighted. So in the particular case, Derrington found that the relevant US terms and conditions were easily located. All Mr. Ho had to do was click on a link and he would find them and he could read them at his leisure. And also, he believed that there was sufficient emphasis provided in the terms and conditions to the two relevant clauses. So the exclusive jurisdiction clause and the class action clause were identified quite prominently in the contract. So now that, I guess, there was a view that Mr. Ho had notice of the relevant clauses, the question was whether the contract's terms were unfair. And in Derrington's view, a clause that merely required Mr. Ho to pursue his legal claim individually was not an unfair contract term. It simply was recommending that there be a different approach to pursuing a claim. If the term had sought to eliminate Mr. Ho's legal rights to pursue any claim at all, then that would probably have been considered an unfair contract term. But simply mandating an individual case versus a class action case was not considered to be unfair. And there you start seeing in Derrington's judgment a few quite negative comments about the class action procedure, and you just get a feeling that he doesn't really like class actions. Here he goes, rather, limitations directed to the alternative litigious path created by the modern phenomena of class action. So you're getting a bit of a feel there that Derrington doesn't really like class action. So one thing that fortressed Derrington's view, or buttressed his view that it wasn't unfair, was the fact that there existed 11 individual proceedings in the US courts which are being pursued at the moment. So that suggested to him that pursuing an individual claim was not unduly burdensome, that he could have easily pursued an individual claim himself. Also, he noted that in the US it's a different cost regime than Australia, where in Australia obviously costs follow the event, but in the US there's a no cost regime in many jurisdictions, which means each party pays their own costs. So he believed that the no cost regime potentially reduced any perceived imbalance between Mr. Ho and Carnival in individual litigation. Then he makes a few more comments about class actions, which are somewhat concerning. Here he says that he refers to the class action process where recovery is often significantly eroded by the entitlements of both the litigation fund and the class action lawyers. So negative there about the recoveries of the law firms and litigation funders, and then makes a further reference there to the fees charged by the lawyers and deducted from any proceeds paid by Princess. And it says invariably lead to substantially greater costs and expenses. And effectively, the class action process is a very expensive process because I guess plaintiff lawyers and litigation funders are taking a big chunk of the settlement. So then he has this quote, which I found quite surprising. He says the US Supreme Court also recognised that class actions in general have the potential to impose inter rorem settlements on defendants. Such risks also exist in the Australian jurisdiction. The enormity of the claim sought to be imposed on a defendant by a single action, together with the cost of defending it, provide a significant incentive for a defendant or its insurer to attempt rather than face the ruinous sequelae of an adverse judgment. Now, I didn't really know what sequelae meant, so I had to look it up, but it actually means a condition which is a consequence of a previous disease or injury. So this is a very negative comment to be making about class actions, that effectively class actions impose on defendants inter rarem settlements. So they're forced to settle not because of the merits of the case, but simply because of the legal costs associated with pursuing the claim. And to describe the ruinous sequelae of an adverse judgment and use that word sequelae, which, as I said, refers to disease or injury, is obviously quite pejorative. So getting a feeling that Derrington's not a big fan of class actions. There's also this quote at 267 where he describes the legitimate interest in avoiding the travails of class actions. So clearly, Carnival had a legitimate interest in avoiding such travails. And then he talks about not seeking to engage in a qualitative comparison of the level of abuses of the class action procedures across particular jurisdictions. It suffices to observe that the class action procedure can be abused to oppress defendants by reason of the enormous costs which tend to be billed by the claimant's legal practitioners and the large portion of recoveries required by funders, each of which necessarily increases the amount for which the action might be resolved. So here he's making a lot of gratuitous negative comments about class actions, which are entirely unnecessary, not needed to be discussed, and clearly disclosing a very adverse view of class actions generally. Then he made this comment, which I must admit made me laugh a bit, because the question was risen whether the substantially unequal financial position of both Mr. Ho versus uh, Carnival was something that would suggest there was an unequal bargaining position. And he says in his judgment, the active case management techniques which would produce the expeditious and efficient resolution of litigation should counter this problem. And he further adds the cure processes which offer a substantial bulwark against any deep-pocketed tactics in the course of a proceeding. So he is suggesting that the fact that the parties have unequal financial resources doesn't matter, because the court processes are able to overcome this unequal bargaining position. And that just seems entirely unrealistic to me. That simply is not correct. Clearly, there are many arguments saying that the unequal financial position of litigants in litigation is a big concern, and that's what all the access to justice um, reforms over the last 20 years have been about. So this just seemed like a somewhat unreal statement for a federal court judge to be making. Then the next question that had to be considered after the conclusion was that the terms, the exclusive jurisdiction clause and the class action waiver clause were not unfair terms, is whether Section 23 was a mandatory law which could not be excluded, and the judge concluded that there was really no evidence to suggest that Section 23 was a mandatory law. There was no provision to say that you could not contract out of it, so that argument fell flat, and Alsop agreed that it was not a mandatory law. Then he looks to public policy arguments as to whether you can contract out of Part 4A of the Federal Court of Australia Act, which is a class action provisions, and whether that's inconsistent with the person's right to pursue a class action. And he did not think that there was any argument to say that you could not, there was a inconsistency between a class action waiver clause and the rights which individuals had under Part 4A. And Alsop agreed with that argument as well. But the key issue here, and this is clearly obiter, but it does raise some very important questions about Section 23, relates to the extraterritorial issues. And that's under Section 5 of the Competition and Consumer Act. So under Section 5 of the Competition and Consumer Act, a lot of the provisions of the Competition and Consumer Act and the Australian consumer law are extended to acts outside Australia. And it says that for the Australian consumer law, the jurisdiction extends to engaging in conduct outside Australia by bodies incorporated or carrying on business within Australia. So effectively, Section 23 could be extended beyond purely domestic conduct if Section 5 can be applied. But what Darrington points out is that Section 23 is purely declaratory. It says a term of consumer contract or small business contract is void if. It doesn't have any reference to any conduct. It's unlike other provisions in the Australian consumer law which refer to conduct occurring in trade and commerce. So it doesn't actually state that there's a conduct element, and therefore arguably Section 51G or the extended operation of the legislation does not apply to Section 23. Now, he explains that point at 284, where he says Section 23 merely declares the specific types of contract which would be a void. There's really no evidence to suggest that section or any basis to believe that Section 51G should attach to Section 23, as there's no element of engaging in conduct. And so he says, with great respect to the learned primary judge, the preferable construction is that while Section 51G may extend the operation of the Act to conduct engaged outside Australia, there is none identified in Section 23 on which that section might operate. So effectively, Section 23 has no extraterritorial application as far as Section 15G is concerned. Now, obviously, obvious concern of that is that there's a strong ability for particular corporations to contract out of Section 23. So they could deliberately circumvent the operation of Section 23 due to this problem with Section 51G and the absence of conduct in Section 23 by including contracts which have an alternative choice of law in them. So there's a big problem here that he's identified, that a lot of the impacts of Section 23 could be avoided due to Section 23 not having a conduct element. Now, also approached the issues pretty much like Darrington. He didn't see that the loss of capacity to participate in Australian class action would be unfair. It was really a case of Mr. Ho having an ability to pursue an individual action in the US. The terms were transparent, attention was drawn to them. So he didn't think that there was any reason why the terms could not be enforced. He said there was nothing contrived about the way the choice of law clause had been included in the US terms and conditions. He noted that Mr. Ho was not an Australian consumer, and there was no apparent attempt to sort of get round Australian law, including no attempt to circumvent Part 4A of the Federal Court Australia Act. And so there was nothing particularly problematic about excluding the US passengers from continuing in the Australian class action. However, he was a bit more concerned at the implications of Darrington's judgment, which would have suggested that the same rule would have applied to all consumers, regardless of whether they were Australian or US consumers. In his view, Allsop was concerned that it may be unfair and unjust to include a class action waiver clause in an Australian consumer contract, because it would seek to disadvantage Australian consumers. So he really put a lot of emphasis on the fact that Mr. Ho was not an Australian consumer, and therefore there wasn't a lot of concern in this particular case. But he'd be reluctant to expand the application of these principles to Australian consumers. And he was particularly concerned about Darrington's comments about Section 51G, which focused very much on the formation of the contract and not the performance of the contract. And he said that he had a different view, that he believed that the Section 23 and 24 could have an extraterritorial application under Section 51G by the use of 15A of the Act Interpretation Act. So he says there's another way for the extraterritorial application of Section 23 to be found, but he did not believe that this was an appropriate case to really decide that. Rather, it'd have to wait for a more testing practical legal problem in the future. And he said that, like, it's open to construe Section 51G as applying to Section 23 of the ACL. It's artificial to divorce the making of the contract from the contract as made, and that really taking this approach that Derrington's taken to sort of say, well, Section 23 is declaratory, there's no reference to conduct, Section 51G requires conduct, therefore Section 51G doesn't apply to Section 23. He said that was maybe not the correct interpretation to take, that we are looking at beneficial consumer legislation, so we've got to try and take a different approach which construes it beneficially in accordance with the legislature's purpose. And he makes it clear that the way Derrington's approached it may be too limited. So he made a specific point of disagreeing with Derrington on this particular issue. And he made the point again that the Commonwealth Parliament could not have intended to create this opportunity to circumvent the protections offered under the unfair contract terms. An approach to construing the relevant legislation has to be to advance the intention of Parliament. And then he says the protection of the Australian consumer is the very context and subject matter to which the ACL is primarily directed. The specific policy of Section 23, making void certain provisions in standard form contracts, is directed towards practices which the legislature has deemed unfair and which should not be enforced as part of a fair bargain. So he's concerned that an interpretation that Derrington's outlined may defeat the whole purpose of the Australian consumer law and the protections it's seeking to offer under the unfair contract term provisions. Now, Rea's dissented, he took a totally different view. He looked at whether it was permissible to effectively contract out from Part 4A of the Federal Court of Australia Act, and he concluded that you could not circumvent the operation of Part 4A. The section was, well, the whole part was set up to assist poor and less educated people, to protect their interests, and clearly to allow such circumvention would set that reform at naught. And then he believed that such a construction of Part 4A, the permitted enforcement of class action waiver court, would not only negate the legislative intention of Part 4A, but also would allow people to contract out of their rights under Part 4A even before they were aware of the class action. And he put a lot of emphasis on the fact that the Part 4A system requires the potential plaintiff to discover the existence of the class action and details of the class action and then make an educated decision whether to opt out. And he thought it was inconsistent for people to be required to opt out of a class action before they ever knew it existed and had adequate information about the pros and cons of signing up. And so he concluded that Part 4A does not enable persons to contract out of being group members before the commencement of representative proceedings. So he would have dismissed the appeal on that basis. He didn't have to go into the issue of whether the terms were unfair contract terms and thus unenforceable. So just some commentary. It's a very inconclusive judgment, as you can see. A number of the issues that were agreed upon were factual issues. Don't really raise a lot of law, like was the travel agent the agent of Mr. Ho, and as a consequence were the US terms and conditions incorporated into his passenger agreement. that was they were factual issues, but it's quite inconclusive on a number of other issues. I guess one that was concluded was that Part 4A of the Federal Court Act is not a mandatory law. You can actually contract out of it, and that's obviously an issue which there was disagreement amongst the three judges on. And it's clear that class action clauses are not per se unfair contract terms. It depends on the circumstances of the case. I think Derrington may conclude that class action clauses are not unfair contract terms. Allsop seems to be suggesting that it sort of depends on whether the consumer is an Australian consumer or not. However, there is a real concern raised by this judgment that it may be possible for large foreign corporations to contract out of their obligations under the unfair contract term laws. And that's a real issue. And when you think about how the penalties are increasing for unfair contract term breaches at the end of 2023, I think companies are going to have a lot of incentive to try and contract out of liability, because as you may know, the penalties for breaching the unfair contract term laws are going to be introduced in 2023, and they're going to be starting at the new high penalties, which is $50 million or 3 times the benefit from the contravening conduct, or 30% of adjusted turnover, whichever is at the highest. So that's a huge penalty. And so I think a lot of companies who may be able to take advantage of the commentary in this case may seek to do so to contract out of their liability. It seems a sensible thing to try and do on a commercial level. So I think there needs to be something done to fix up the question marks over the extraterritorial application of Section 23. Now, we could wait till a new vehicle comes to the federal court, and hopefully Allsop's view prevails, and they've found a way of applying Section 51G to 23 and giving the section extraterritorial application. But what would be a much better approach is for the Parliament to look at amending Section 23 to ensure that there is a conduct element, and so that the concerns that Derrington raises do not actually manifest in a real life case. So I think there may be an argument for legislative amendments to Section 23 to include some conduct element. So that's all I had. I think it's a disappointing case. I think the judges all went off on different directions. And I think the most disappointing bit is a lot of the negative comments made by Derrington about class actions. Not only were they, I think, quite unfair, but they were entirely gratuitous and unnecessary for the judgment. So I think judges should exercise a bit more prudence when they're writing their judgments, not to make such statements. Clearly, some of the statements made about the absence of inequality of financial position in litigation is quite remarkable statement for a judge to make, and shows, I think, largely how out of touch some judges are with the way litigation is run. Often litigation is won due to the fact that one party has access to significantly more resources than the other party. So that's all I had. Hopefully that's been helpful. It's a disappointing case, but I think that outlines the main issues to take out of it. If you have any questions, feel free to give me a call or send me an email. Bye bye.